So number 4, back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number 4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told away from number 4, told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination. Now, after witnesses have testified, the state's seeking to admit a document
Once
that
again,
has number 4 in it. And it's just, I mean, I don't know what we're doing.
Okay.
Your Honor,
Number 5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number 4 not being addressed here is more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it, and we change it, and we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
He doesn't
denies.
have personal knowledge
That's
that they were planning it.
Judge, that's the point that I'm making, that he says, I did not know that. The fact that something that,
Even saying I did not know that is sort of like,
or that's not
"Oh,
true.
it's true, but I didn't know it."
No, he's saying that's not true. He is
No,
saying
he's
that-
not. He's saying, I don't know. I think maybe XYZ. That is not coming in. That needs
finally.
to be kept out under 403 if nothing
No.
else. And
Look at Atkins. Hold on, look at
that's really the only
Atkins.
thing-
I know it's worth the buffer. Look at the side eye from Atkins at the table. Ooh-wee. And I don't know. Usually when it buffers when I
needs to be
reload like
kept
that,
out
but
under
look at him.
403 if nothing else. And that's really the only thing you wanted in, right? So
I didn't hear you.
is that really the only thing from this that you wanted in?
When you say this, you mean
From this being this part, the 8:43 PM email from Mr. Wright that is
Oh.
included within 460Y.
I didn't even the language of what he says, I didn't even need to have that in. I mean, I understand why that would be considered, and I understand the court's position there, why it would look like something was pre-planned. The reason that I was asking or seeking to have the assertion in is just to show that he says no to it. We could take out all of number 4 under Mr. Wright's email and just say, no, he denied it.
Well, we can't make it say something. it
No,
doesn't
not
say,
put the
so
word
how
no.
can we do
He
that?
said, Mr. Wright said on the stand
Okay.
that is something that we did not agree to and we took
Okay.
out.
And that's exactly the point. Mr.
Exactly.
Wright said all
Alright.
this stuff on the stand.
We're not going to be admitting 460Y. And that leaves 451 through 456. And those kind of, what would be the theory under which those would come in?
It, Your Honor, provides, it contradicts Mr. Sledge's testimony when I presented him with a prior iteration, that there was an objection to it being called a prior iteration. And I asked him to show me things that were different. It contradicts his testimony that he saw prior iterations and was allowed to make changes to the prior iterations. He said on cross, the first time he ever saw that plea agreement, it might have been the first time that he saw.
Well, that was the first time he saw that plea agreement because all of these were prior versions.
And when I asked him, did he see any prior versions? My recollection is that he denied.
I don't remember that. I think he said the back and forth between us and the state was up to my lawyer. I left that to my lawyer.
And Mr. Wright clearly testified that he took a version to speak to Mr. Sledge the night before.
And I'll look back at.
All right. Well, subject to that actually being some kind of so that would be what, impeachment by contradiction?
Yes, it would.
Okay. Well, you can let me know if he actually testified
Your Honor.
in the way that you remember it. Yes.
And I don't think we should have to litigate this again, and I'm going to explain why.
Okay.
The state, under the state's theory, well, I mean, why don't they just do this for every case? They could write out their facts, just send them to a bunch of witnesses. Witness doesn't need to initial them at all, and then they take the stand, and then we just start bringing in all copies of documents that they wrote and sent to witnesses that witnesses looked at. I mean, it's false facts here. It's facts that haven't been adopted on these documents. There's inadmissible statements on these documents. It's a mess. And we didn't create this. We didn't tell the state to do it this way. We didn't tell the state to write their documents and then send them to an attorney, write the statements and send them to an attorney and see what the co-defendant says or the witness says. We didn't tell them to do it this way. They created this problem.
I understand. You can get back to me if you can find some kind of testimony that you think lets you get this in. Right now, they are excluded.
Yes, Your Honor. Thank you. And I will look for that.
Yes.
I can't say with certainty, but I'm just going to ask if there is also a case which I, in my mind, in the recesses of it, believe that it may address specifically like
Okay, well.
iterations.
Sure.
Okay, thanks.
Okay, 60-second, all caps. Holy moly.
Even if Mr. Sledge did say there were never any other versions, and which I don't think he said, you've disproved that by presenting the testimony of Mr. Wright. So I think given the number of 403 concerns there are with 451 through 456, I'm going to just stand on my ruling excluding them.
Your Honor,
Hallelujah.
with respect to the
No, shut up.
403 concerns that were raised, given that 403 addresses matters that are substantially more prejudicial than probative, and given the extent of the cross-examination and the efforts to undermine the willingness or knowingness of Mr. Sledge's statements, essentially even in the arguments that are made, it's essentially the argument is that this isn't a statement that Mr. Sledge made. Showing that Mr. Sledge, showing a prior statement, contradicting that testimony.
That's what 444Y is. And that's it.
The,
As redacted.
that's the ultimate
That's
one that he
I
signed.
know. And
But
that's-
showing, yes, it is. It
I
is.
know.
Showing that he was untruthful, and letting the jury decide, why are you telling stories about that? About seeing a prior version, we believe is strong evidence that allows them to judge his credibility, why he's saying what he's saying, any bias he may or may not have, and
Look at
help them
Steele.
to determine the truth of which statement they should believe. So we would ask that the court, I don't know, revive its prior ruling,
5 minutes ago.
revive the ruling that the court
Okay.
made.
Denied. Let's move on.